Idaho. And I am currently the East Hub Designated Examiner Regional Program Specialist. The East Hub in the Department of Health and Welfare is made up of regions 5, 6, and 7. So that's essentially the area surrounding Twin Falls on east, all the way over through up to Teton County and Fremont County, all the way down to Bear Lake County. So we cover a large area. I don't have time probably to have everybody introduce themselves, but if I could get you guys to put in the chat box maybe where you're from and what type of work you do in the field. That way I can have a better idea of kind of who my audience is as we go through. So we've got some Boise. Idaho, great. Washington, welcome from Washington. Right, we've got a pretty wide range of different areas throughout Idaho. Great. Well, let me get started. And Mary, my presentation isn't.
Why don't you stop sharing it and reshare it? And I bet that might make it work out.
Let's try that. I was talking with Mary before we started about how when I went to school, I was used to doing presentations on overhead projectors. So PowerPoint is can be quite the challenge for me. It's still not wanting. Slide control, let's try that. No.
Okay, Jessica, just go ahead and stop sharing and close the presentation and reopen the presentation, and that'll probably take care of it. And otherwise, I can pull it up and run it from my end if need be.
Okay. There we go. Okay, are you seeing the second page?
Yes.
Okay, so essentially by the end of this presentation, you should be able to have kind of an overall general understanding of the civil commitment law here in the state of Idaho, be able to understand how to access the statute and how to kind of navigate the Idaho statute that covers the civil commitment law. And then the criteria that we use to determine whether or not somebody meets commitment standards and that DE process, along with the timeframes that the law allows for each part of the commitment process. So I'll start with kind of some basic legal overview of where this law kind of developed, also how to access the law and how to navigate that, along with the overall process of the civil commitment statute and the timelines that each section of that process allows for. We'll cover some myths or misunderstandings that we often hear about civil commitment, and I'll go over the DE process and the commitment criteria that we look for, as well as some exclusions from civil commitment that the law actually outlines, and then some additional options that we talk with families about that maybe fall in that exclusional area. So essentially, the country went through deinstitutionalization, it became necessary to put laws into place for individuals that needed to receive treatment, but didn't want to access that treatment on a voluntary basis. Those civil commitment laws are state by state. So Idaho's laws are different from other states, although a lot of the states have very similar statutes in place and very similar criteria. But essentially, it's not against the law to have a mental illness, obviously, or to be symptomatic, or not to treat that mental illness, as well as to behave kind of outside what we would consider maybe the norm of American society. And individuals are free to make their own decisions about whether or not they want to access treatment until it becomes dangerous. And that dangerousness is really what the civil commitment laws are based on. So it's a pretty significant process because it's the only time, aside from being arrested, that an individual's rights can be suspended. So we take it pretty seriously, and we don't want to just go committing people that don't meet that criteria, because it is a pretty significant thing to suspend somebody's rights here in the United States. So it is a court process. So this presentation is not going to be super riveting and exciting. It's very law-based and just helping to kind of differentiate between the different ways in which the law can be interpreted. And the commitments are a civil matter. So they do go on to somebody's record, but they are closed cases under civil cases. They're not criminal. The statute does allow for criminal commitments when somebody has been accused of a crime, and that's what we call the competency restoration process. And so that's a different statute than this one. So I won't be talking about that one. But the civil commitment allows for those individuals that have a mental illness that is not being treated or not stabilized with its current treatments, and the behaviors and the symptoms are outside what's safe, basically, and dangerousness to themselves and to the community. So this is and I'm going to actually stop sharing this and show you what this looks like, because it can be a little confusing. So when you click on that link, it will pull up this web page. So it's in the Idaho statutes, it's Title 66, Chapter 3, which is the hospitalization of the mentally ill. So as I scroll down, you can see there are a lot of different statutes that we as designated examiners have to take into consideration as we're doing this job. And so you can click on the individual ones to look through. So this first one is all the definitions, or you can actually go and download the entire chapter, which will pull up every single statute in consecutive order, which can be a little intimidating, but if you aren't sure where something is located, that might be the easiest way to navigate that. So any questions so far about how to access that, or what that looks like? Let's make sure we're okay. I'm not seeing any questions, so I will go ahead and move forward. Okay, so this is an overview, and I believe Mary is going to include this in the email she sends out, and I do believe it's in the waiting room or where you can download it. But it's a great overview of the entire process and just a flow chart of the different things that can happen throughout the process. So starting with the Idaho code, I'm going to break this down for you. So I'm going to go off of this screen, but I will have it again at the end of the presentation so we can kind of go back through and make sure that we hit every section of this.
Jessica,
Yes,
I did just put the link to it in the chat, so you can click on that link and pull it up. Each person can themselves.
perfect. Thank you. So this is oftentimes something too that we'll hand out to patients or families if they have questions about it, just in the sense of what that process is going to look like. So it's definitely helpful, and we use it quite often. So the first part of the process, essentially in the statute, is called a detention without a hearing. So this is referring to that suspension. Somebody's able to be taken into custody without a hearing or an arrest warrant. This statute allows for a peace officer or a physician or medical staff, so a physician's assistant, a nurse practitioner, anybody acting in that, in the emergency department of a hospital, or even if the patient is admitted to said hospital, then their treating physician at that hospital. It doesn't allow for physicians in the community. So essentially it is just for the physicians at the hospital or a peace officer. And by peace officer, that also covers not just law enforcement, but it covers probation and parole officers as well. So they have the ability to take somebody into what we call protective custody. So there's two types of holds that an individual can be placed under. Sometimes you'll hear these being called involuntary holds or involuntary commitment holds. Oftentimes I hear 24-hour holds. I really hesitate, and I don't ever refer to them as 24-hour holds because it's very deceiving, because the 24-hour time frame for the hold is not when the patient is necessarily going to get released. It's just the 24 hours in which that hold needs to be submitted to the court to start that civil commitment process. So a lot of times we'll go into the hospitals and we'll meet with individuals who have been told that they've been put on a 24-hour hold. And it can be very frustrating for them when they find out that no, not at the actual end of the 24 hours, that doesn't necessarily mean they will be getting released. But the protective custody hold is the hold that can be placed by law enforcement or the emergency room or hospital physician, and that then gets submitted to the court. And an administrative hold is actually a separate section of the statute that actually, in order for that hold to be placed, the patient needs to present to the hospital on a voluntary basis. So that's somebody that comes into the hospital, is seeking help, maybe gets admitted to a psychiatric unit, and then decides that they would like to be discharged. And so the treating psychiatrist then at the psychiatric hospital makes the decision that that person isn't safe to be discharged. And so they can start that administrative hold process. And then that gets submitted the same way. So that hold allows for a 72 hours before it needs to be submitted to the courts. So that just allows for, it excludes the weekends essentially and the holidays. So when somebody is placed into protective custody hold. The hospital that they get brought to, because when a law enforcement officer puts somebody into protective custody, they have to take them to the closest emergency room for that person to be medically cleared. So they don't do an immediate admission to a psychiatric facility. They have to go through the emergency room the same way they would as if they were going for a voluntary admission. So that hospital then has 24 hours to submit that hold paperwork to the county, the prosecutor's office, essentially, of either the county that that hospital is in or the county where the person resides. So if they come to a hospital, here I'm located in Idaho Falls, if they come to a hospital in Idaho Falls, but they live in St. Anthony, then that would get submitted to the Fremont County Prosecutor's Office for processing. And the reason why they allow for it to be submitted to the county where the hospital is because then that allows, because it is a state law, it allows for people that are from out of state to still go through the same process. It's just then the county that the hospital is located in oversees that court process. So after that information is submitted, then that's up to the prosecutor's office to issue what's called a temporary custody order. And that allows for the hospital to continue to hold that person, as well as an order for a designated examination. So when that order for the designated examiner gets signed, the DE has 24 hours to complete an evaluation. Now, this is an area of the statute that is maybe not as clear as some other areas. The way that it reads allows for some counties to interpret it a little bit different. So we have some counties in the East Hub that interpret it as the examiner must see the patient within 24 hours, and then they must make a report to the court within 24 hours of that examination. So some counties that's actually 48 hours, but other counties, they see that as 24 hours to meet with the person and submit the findings. I would say in our hub, it's a majority of them is the 24 hours to see the patient and submit the report. But we do have a couple of counties in our hub that interpret it as the 48 hours. So that's where I say that 24-hour hold can be misleading, because it starts the time frame from, if it takes 23 hours for them to submit the hold to the court, and then the court issues that order, that starts another 24 to potentially 48 hours of a time frame for that evaluation to happen. So that's where it can get misleading for those patients. So after we submit our, as a first designated examiner, we submit our certificate to the court. If it is a positive certificate, meaning that person does meet commitment criteria, then the court has 48 hours to appoint a second or senior designated examiner. The statute it gets updated quite frequently throughout the years. Most recently, it was updated in, it was updated during the legislative session in 2022, and then took effect July 1st of 2022, where it actually changed some of the definitions, and the senior designated examination definition was actually added at that point in time. So at least one of the examiners has to be a senior designated examiner. Most of the counties in the East Hub have the junior designated examiner as the first DE, and then the senior designated examiner as the second DE. But that's not necessarily consistent across the entire state, although we are trying to work towards more consistency throughout the state. But with so many entities involved with the courts and the hospitals and everybody, it's hard to get everybody doing the exact same thing. So the senior DE, once they have those orders, they actually have 72 hours to see the patient and submit their report to the court of whether or not that patient meets criteria. If the senior DE submits a positive, meaning that the patient meets commitment criteria, then the court sets a civil commitment hearing that the statute allows for that to be no more than 7 days from the return of that senior designated examiner certificate. So the statute has identified a senior designated examiner as somebody who has at least 3 years experience as a designated examiner and 5 years postmaster's degree experience. Before they had this specification, it had to be a psychologist or a physician or so forth. But I know that a lot of areas in the more rural parts of the states were having a hard time having enough people that were qualified to be senior designated examiners. So they did make that change. Like I said, that went into effect last July. So this is another part of the statute which talks about a person's right to be represented by an attorney. Generally, the patients are represented by a court-appointed attorney, a public defender, which generally is, in my opinion, probably the best, because those public defenders do these hearings all the time. They're very familiar with the statute. A handful of times that a person's hired a private attorney, it's been a little bit more challenging, I think, because they're maybe not as familiar with the statute and what all the ins and outs of it are. So, but they do have the ability, if they want to hire their own private attorney to represent them in the case as well. The statute also mentions in there that the hearing shall be held in a manner that's not harmful to the proposed patient. So most of our counties allow for the court hearing to be held in the hospital setting, because it can be kind of traumatic for a patient to have to get transported by law enforcement to the courthouse. And with it being a civil hearing and not a criminal hearing, it feels very criminal when somebody's transported by law enforcement. A lot of times they have to be put into handcuffs and in the back of the law enforcement vehicle. And it is very traumatic. So I think it's much better on the patients that are able to then have the court hearing from the hospital. They're able to talk with their attorney. And since COVID, most of our court hearings are via Zoom like this. So everybody is able to be present kind of from where they're located, which has made it a little bit easier for us to do our DEs for hospitals that are further out of the area. So in Idaho Falls, we often have patients that are admitted to Canyon View Hospital in Twin Falls, which is quite the drive. So we do a lot of those virtually as well. So the civil commitment statute does allow for essentially the HIPAA rights of patients' information to be waived, for the designated examiner to be able to gather enough information from enough different sources so that we can make an appropriate decision of whether or not that patient meets criteria for commitment. And a lot of times when the patient is brought into the hospital, if they're there on an involuntary basis, they oftentimes are not cooperative, do not want the DE to speak with family members or with providers or different things like that, which makes it very difficult to do an objective examination of a patient who isn't authorizing us to have access to any information. So the statute allows for the DE as their role to be able to access whatever information we need to in order to be able to make that decision and be an expert and competent witness to testify during those civil commitment proceedings. It also addresses the disclosure in the sense of that all the certificates, applications, records, all of that are sealed. So they can't be disclosed to anybody. If you have somebody that runs a background check on somebody, it will just show a sealed case. It doesn't show that that there's actually been a civil commitment hearing that's accessible or visible to other people. Another thing too that I want to mention in this section, we as DEs are very cognizant of the relationships that family members and treatment providers have with those patients. And so if we are speaking with those individuals and gathering that information from them, we are not testifying to the sense of we heard this information from this individual. We just say, collateral sources have provided this information, or, we've received this information through collateral contacts. And we don't, our job isn't to damage any of those support and relationships that are already there and necessary to the patient's, their wellness and their ability to have a good support system either. So we definitely try to keep those sources confidential in the sense of when we present that information to the court. So if we have had a first positive DE and a second positive DE, and we've now had the hearing scheduled, we've testified at the hearing, and if at the end of that hearing, the judge finds by clear and convincing evidence that the patient is mentally ill, and because of that mental illness, they're either likely to injure themselves or others, or they're gravely disabled. And I'll go more into the specifics of those later on. So I'm not going to define those right now, but they need to find those things to be in place that the court then commits the patient to the custody of the Department of Health and Welfare. And this part can be very, very scary for the patients and even family members if they actually are present in the court hearing. So I usually prepare the patient ahead of time because they say for care and treatment for an indeterminate period of time, not to exceed 1 year. Patients are never in the hospital for that long. And very rarely is anyone under commitment for that long, but that's what the law allows for. So that's what the judge reads into the record. The law does then say that once somebody no longer meets criteria for commitment, that commitment needs to be terminated. So it can be very scary when they hear they're committed for a year, but it's usually much, much less time than that. So like I said, the law does allow for that the commitment stays in place until it's terminated, and it is unaffected by whether or not they are released maybe under an outpatient commitment or whether or not they get transferred to a state hospital. That commitment stays in place until it's terminated with the courts. And it has to be terminated once the patient no longer meets that commitment criteria. So with the law and with all the checks and balances that need to be in place, especially with this being the only time that somebody's rights can be suspended, they do have a requirement that after the first 90 days, we have to review we have to complete a review of the treatment progress and why the patient still meets criteria for commitment, and we have to submit that to the court. And then every 120 days afterwards. So then the court oversees the reasons why that commitment still needs to be maintained. And if they disagree with that, then that commitment ends up terminated. So it doesn't allow for any one individual or one entity to have total kind of control and decision making. Make sure that we're following the law. Generally, when a person is committed, they stay at that community hospital that they are currently at until a bed at a state hospital is open. The state hospitals always have wait lists, so they get, if the person looks like it's going to be a little bit of a longer term hospitalization, then they get put on that wait list for the state hospital. But we can terminate the commitment from the community hospital if that patient's symptoms stabilize while they're there. So that process is just then the treating psychiatrist at the community hospital makes a request for a reevaluation of commitment. And then we as the DEs go into the community hospital and reevaluate whether or not that patient still meets that criteria. So the statute does specify a patient's rights. And when I talk about some of the myths, this area seems to be one of the biggest misunderstandings with commitment. So when a patient is committed, they are committed for mental health treatment only and for decisions about their mental health treatment only. They do have the right to refuse specific modes of treatment. The hospital has the ability to override that right. And each hospital has its own process for how they do that within their own legal system within the hospitals. And essentially that patient has to be basically refusing all modes of treatment. If the person is willing to take a certain medication but not other medications, but they're willing to choose certain methods of treatment, then it's very hard for that hospital to override that right. But if they're refusing all modes of treatment, then that gives the hospital a little bit more to work with. In the court hearing, they call that a medication override. And generally the commitment process allows for a medication override to happen if necessary. But then they have to present that information to the court, and that court has to be okay with that that specific mode of treatment being forced upon that patient. The patients have the right to have contact with their attorney at any point in time. So even sometimes when a patient is hospitalized, they may get put on phone restrictions or different things based on their behaviors within the hospital and within the hospital's rules as far as certain levels of that they can move about the hospital versus the unit, different things like that. Sometimes they're making phone calls that are, we've had patients that, will call 911 or dispatch or things like that, or they become kind of harassing to family members, and the family members request that individual be placed on phone restrictions. That contact with an attorney cannot be restricted for that patient. They have the ability to contact their attorney at any point in time. To receive the visitors at reasonable hours in their own clothes, that's really based on kind of each hospital's policies, and most of those policies are safety-based, obviously, and not just for the safety of that individual patient, but for the safety of all the patients on the units. And the sealed mail that's the hospital's will make arrangements for the individual to be able to communicate by mail. The other piece that they have the right to do, which can be kind of confusing, I think, in a sense, is that they have the right to enter into basically exercise all of their civil rights other than just their decision making. So they have the right to vote, they have the right to buy and sell property, they have the right to their money, anything like that. They have the right to consent to medical treatment. So if they need some sort of a medical procedure, that's something that they have the ability to consent to or refuse to consent to. None of those rights are limited. Essentially, their only right that is limited is their ability to leave the facility and to make those treatment decisions regarding their mental health treatment. So this table kind of goes through the time frames of what we're looking at for an individual going through the process. So once again, that 24-hour hold is deceiving, and because really that just starts the process of something that can really go up to close to 2 weeks before a commitment is put into place. So obviously the protective hold custody kind of starts that process. And then that first 24 hours is for the facility to send the paperwork to the court. And then the next 24 hours, which can be up to 2 total days, is that first exam and report to the court. Dropping down several is the appointment of the second designated examiner, which then that can be up to 5 days before those orders are sent out. And once those orders are sent out, they have the additional 3 days, and then the hearing has to be scheduled. So this is just kind of an overview of really how long the process can be, but it can also go pretty quickly depending on how quick everything goes. If the paperwork is submitted very quickly and the orders for the first DE are issued right away, and it can extend out, or it can be much shorter. So that's just kind of an overview of those timeframes. Do we have any questions so far about the overview of the whole process? No? Okay. Harper holds. I'm not familiar with that term.
If I can unmute myself, Jessica, it's a term that I've heard out in the prison for those that are in the max facility that are on what they consider Harper hold, which is, I would imagine, aligned with this, but I wasn't sure and wanted to ask that question if anyone has any information on that.
A Harper hold? I've never heard. And is that in Idaho?
Yeah, at IMSI, our maximum security facility, we have individuals on C block that are on a mental health hold that have not committed a crime, but they're there because I would imagine the state hospitals have run out of room.
No, so the individuals that are in the Department of Corrections have been deemed by the court to be dangerously mentally ill. I've never heard the term Harper hold, but we use DMI. So that means that their behaviors are such that they are too dangerous to be maintained on a psychiatric milieu. So they need even a higher level of care than what is able to be maintained just in a milieu. So we have, I believe, 8 or 9 beds that are at the maximum security prison there, and then I believe 2 beds that are at the women's prison in Pocatello for those that are deemed dangerously mentally ill. So Harper So it's like that's, Okay, yeah, I've never heard that term, Harper. So that isn't those individuals that that are committed under a dangerous mental illness, which is a separate statute actually than the civil commitment. We most often see that designation with individuals with competency when they're committed under the 18-11-12 statute for competency restoration, but we do have the ability for individuals who have been civilly committed to have a hearing with the court to deem the patient dangerously mentally ill if that patient has been essentially they've been violent in a local community hospital, they've been arrested and are being maintained in a community jail, and that they're not able to be admitted to the state hospital for safety reasons. Then they get committed to the Department of Corrections and they go to IDOC for initial stabilization, and then a lot of the times we do a step down. So where they're initially stabilized and no longer dangerous, that they can be maintained in a community hospital, then they'll step down to one of the state hospitals and continue stabilization there before they discharge. Any other questions? That was a great one. I'm going to actually do some research on the Harper hold. So one of the things that I like to remind individuals, especially I feel like it's significant here in the state of Idaho, is that the civil commitment process is not a consequence-free process. There are consequences to committing somebody civilly, in that it can affect their ability to pass background checks for purchasing firearms. It can impact their ability to pass security clearances. So we have the INL here in Idaho, and individuals that work there have to pass pretty stringent security clearances. And so I know that that's something that we as designated examiners are very aware of. And often if somebody is in a position where we also have several National Guard units and the Air Force Base, and just multiple different areas in the state of Idaho where somebody can work or be involved and really impacting their ability to continue with their line of work. Not just even to mention all of the individuals that enjoy hunting and things like that, where that may impact their ability to even just engage in their hobbies. So that's something we like to make people aware of. If we can always move to get the individual to a place where they are willing to accept treatment on a voluntary basis, and sign into the hospital as a voluntary patient, then it's always in their best interest to do that. So this is just the federal laws, and it does require each individual court to report those things. I'm not sure how many of the counties are actually doing that in the state of Idaho. I know some of the counties are doing that. So that's just something that I think is good to be aware of. The statute does allow for a method to apply to have those disabilities removed and have their rights to own and purchase firearms reinstated. So I'm not going to go into the specifics of that, but that is one of the individual sections of the statute to that appeal process and how to go about that. So, like I said, some of the myths and misunderstandings that we hear often with people under commitment. I hear often kind of I was a ward of the state, or that. Sorry about that little disruption. So a ward of the state, or that we become their guardians, or that the department has power of attorney. None of those things is the case. That we do not become the guardian. We only only have any sort of authority over their ability to make their decisions for their mental health treatment. And we generally don't commit individuals that have a guardian, because essentially, when I go through the commitment criteria more specifically here next, it might make a little bit more sense. But essentially, we have to then, if an individual has a guardian, we would have to not only present information to the court as to why the individual needs treatment, but we would also have to present information as to why the guardian is incapable of making those treatment decisions. So, and most of the time with individuals with guardians, that the guardian is a responsible person who makes those treatment decisions for them when necessary. So that's not something that we see that often. Every once in the times that I've seen that happen over the years is really more along the lines of the guardian isn't reachable. They're either out of the area and unreachable, or at times there has been times too where the guardian has been unwilling to consent to treatment for that individual. But that, I would say, maybe has happened less than a handful of times since I've been with the department, and I've been with the department since 2011. So very rarely. Okay, so going through, okay, I thought I missed a slide. So the overview of the DE process. As a designated examiner, when I am assigned to a case, and we as DEs are not able to do anything with a case until we have that signed order for a designated examination. That is what provides us the authority to be able to go into a private community hospital and have access to records and that patient to be able to start the process. So we have to wait until we have that signed order from the judge. That's something I think that happens to get misunderstood a lot. We'll sometimes get a call from the hospital that says, I've got an order for a DE here, and then we'll say, what judge is it that signed that? And they'll say Dr. so-and-so or officer so-and-so, and it's okay, that is not the order for the DE. That is the hold paperwork, and have to kind of walk through that, because we as DEs can't see the patient legally. We shouldn't have even know about the person being a patient until we have that order for the DE. And so then we initially review any prior records we may have on that patient, with previous commitments, previous services that they've maybe received from the department. We'll request the medical records from the facility where that patient is located. So we generally call it a DE packet, but each hospital kind of includes usually the emergency room records and labs, and then the psychiatric evaluation and the history and physical, and any records that have been generated since that patient's been admitted. If the patient was admitted to the medical hospital first for stabilization, or the ICU or anything like that, we'll request all of those records to be able to review everything. We'll gather information from the staff at the facility, the charge nurse, the case manager, any individuals that have worked with that person or is familiar with the reasons why that person came into custody. And then we will meet with the individual face-to-face at the facility, or like I said, sometimes we do virtual evaluations if the person's at a facility that's kind of out of the area, or if they're with COVID, sometimes the units have COVID restrictions, different things like that. So we're finally getting out of that a little bit more, but and we do the clinical interview with the patient, and then we gather collateral information from family members, friends. I always ask the patient who they would like me to contact to be able to gather some of that information, just because sometimes that will let me know maybe who, if they say, I don't want you to contact this person, that might be another person that it would be helpful for me to contact, just to get a well-rounded amount of information so that I can make the best decision possible. So if the person's in a rehab home or an assisted living, anything like that, and we'll gather information from their housing staff as well. And then before we make a decision, we always consult with the treating physician at the facility that they're at. Doesn't necessarily always mean that we're on the same page with that physician, because we're obviously looking for specific criteria that isn't necessarily always in line with some of the things that the doctors are looking at. So we try to do the best we can and work with that treating psychiatrist, but sometimes we're not always on the same page. So the statute defines a designated examiner as a psychiatrist, psychologist, psychiatric nurse, social worker, or other such mental health professional that is in accordance with Chapter 5267 of Idaho Code. So that essentially outlines the requirements in the sense that we have to be 2 years post master's or higher, so 2 years post graduation, and we have to have 6 hours worth of specific designated examination trainings, which that's something actually that I provide a lot of that designated examiner training to our department employees in the East Hub to qualify to become a DE. And then you have to have at least 4 hours of shadowing a already appointed DE for the process in order to qualify to be a designated examiner. And then you submit your application, and the director of the department then authorizes and appoints you as a DE. So when we go in to do a DE, these are the questions that we have to be able to answer for the court. So first and foremost, is the individual mentally ill? Do they have a mental illness as defined in 66-317? And because of that mental illness, the individual is either likely to injure themselves, likely to injure others, and or gravely disabled. They don't have to be all three, they just have to be meet one of those criteria. And then the final thing that we have to look at is, does the individual lack the capacity to make informed decisions regarding their treatment? That is when I said earlier about the guardian, that's the section that is very difficult for us to make argument to the court when somebody has a guardian, that guardian lacks the capacity to make informed decisions regarding treatment. So that's the part of the commitment criteria that having a guardian kind of excludes those individuals. So the statute defines mentally ill as a condition resulting in substantial disorder of thought, mood, perception, or orientation, and that grossly impairs their judgment, behavior, or capacity to recognize and adapt to reality. And it requires the care and treatment at a facility or through outpatient treatment. So it does have a certain amount of exclusion to that definition. I've got just a little brief thing here at the bottom, but I'll go into the more specific exclusions here in a little bit. But so it's not necessarily, does the person have a mental illness that's defined in the DSM-5, because there are some disorders that are in the DSM that actually are excluded from this. So that's why it doesn't mention the DSM in that definition. What we're looking at for the likely to injure themselves or others, they're in the statute, they're combined together in the definition, but we're actually, when we're looking at commitment criteria, we're looking at each of those as a separate. Are they likely to injure themselves or are they likely to injure others? But we're looking at a substantial risk that physical harm will be inflicted by the patient upon his own person as evidenced by threats or attempts to commit suicide or inflict physical harm on himself. So we're taking into consideration not just the events leading up to their admission, if they've had a suicide attempt or they have expressed thoughts of suicide or had made plans of suicide. We're also looking at kind of that ongoing risk. So each DE obviously has specific training in suicide risk assessment and looking at the different things that elevate an individual's risk. So we're not going in and basing that exclusively on asking the patient, are you having thoughts of ending your life? Are you having suicidal thoughts? Because a lot of the times the patients, when they're on an involuntary hold, the answer to that question is going to be no, because they want to get out of the hospital. So we're really looking on, does that individual's behavior leading up to their admission or their behavior even after their admission match their words? So if they say, I wasn't intending to hurt myself when I took 90 pills, that doesn't really match because that's a lot of medication to take for somebody that just wants to get some sleep. So we're looking at those discrepancies between what they're saying and what they're doing. We're looking at preparatory behaviors as far as, are they giving away belongings? Are they, did they update their will? Did they write goodbye letters or notes or things like that? And we're gathering a lot of that information from those around them to see, what was communicated to those individuals, as well as we're looking at history with them, their history of prior suicidal ideation, prior suicide attempts, prior hospitalizations, things like that. The second B is looking at a substantial risk that physical harm will be inflicted by the patient upon another as evidenced by behavior that's caused such harm or that places another person or persons in reasonable fear for sustaining such harm. So that leaves a lot of, I think, area for interpretation in the sense, causes another person reasonable fear. So this is, we're not going in and just asking the person, are you having thoughts of hurting someone else? What we're really looking at is what behaviors is the person engaging in, and what are their loved ones and supports around them doing that shows that they are fearful of harm. So we're looking at, is the family locking their doors when they sleep at night? Are they sleeping in a different location? Are they taking turns sleeping in shifts so that they can monitor safety? Is the assisted living facility putting in precautions, like they're putting the other residents in their rooms when the person is agitated or expressing some of their symptoms and behaviors? Are they on a no roommate order at the facility, at the hospital? Have they had to have assault precautions put into place? Just different things like that, that the other individuals in that person's life are doing things out of the ordinary to protect themselves. So and the questions that we're often asking the individual, because a lot of times with individuals that have symptoms of psychosis or paranoia, a lot of their behaviors are out of fear for their own safety. They feel that they may be in danger if they feel somebody is after them or following them or has intent to inflict some sort of harm on them. That's when we're really digging into how does that individual know what people may be a danger, what people may be, how do they identify who it is that's following them, or and what would they do if they encountered those individuals. So if you believe that these people are out to harm you and you see an individual that you are sure is going to be harmful to you, what would you do? How would you protect yourself? Those are the questions that we're really looking for, because if somebody says, oh, I would call the police, great, then that's what we would want them to do, and that they wouldn't meet that criteria then. But if they say, I have every right to defend myself and I own all of these different weapons and I would I'd shoot first, that's a different thing. That right there is kind of the things that we would be looking for to see, is that person really going to be a potential harm to other individuals. Obviously the more obvious ones too, with the people that are just already being physically assaultive to family members or even to other peers and stuff on the unit at the hospital. So the last one is actually it's included in this definition as well as in the grave disability, but essentially the proposed patient lacks the insight into their need for treatment, and they're unwilling to comply with that treatment. And if they don't receive that treatment, that based on clinical observation and their history, that they will continue to deteriorate to the point where in the reasonably near future that they would become a danger to others or to themselves. And this was added, I don't remember the exact year that this was added, but this was added to allow for, back before this was added, the statute only allowed for somebody to be taken into protective custody when they've already acted in a way that was harmful. If they had no history of being aggressive, or even if they had a history of being aggressive, if they hadn't acted yet in a way to be violent towards someone else, you almost had to wait for them to do that. But now that if the individual has history, and we know that when A, B, and C happens, that person becomes violent, that allows us to intervene a little more proactively and not having to wait. So grave disability, this, a lot of states actually don't include grave disability. They just look at the dangerousness to self and others. Where Idaho is a little more progressive in that area, where we actually look at this third area, grave disability, and this actually was just updated last year in 2022 and took in effect in July 2022, where a couple of things were added to this definition. But essentially, grave disability means that because of the symptoms of their mental illness, the patient is unable to attend to their basic physical needs, such as providing their medical care, food, clothing, shelter, or their own personal safety. B, protect himself from harm or victimization from others. That's a new one that was added to this section of the statute. And exercise sufficient behavioral control to avoid serious criminal justice involvement is also new. So those B and C are the two new areas. And then D is very similar to the other one in dangerousness, where they have the inability to recognize that they are experiencing symptoms of mental illness, and they lack their insight into their need for treatment. And if they don't receive treatment, then they're going to deteriorate to a point where they will likely meet those other A, B, or C in the reasonably near future. So with grave disability, we're really looking at is the individual's symptoms interfering with their ability to take care of their medical conditions. If the patient has diabetes or high blood pressure or any sort of medical condition that requires regular medications or maintenance, things like that, and the person's mental health symptoms are such that they are not able to maintain those medications, or with diabetes, especially with monitoring their insulin and blood sugars and all of those different things that go into maintaining different medical conditions. Sometimes when patients have a fear that medications or so forth are poisoned, that's not just the psychotropic medications. Sometimes they believe that about all their medications, and they'll stop treating their medical conditions as well. Food, we're not just looking at whether or not the person can access food, but we'll see a lot of times that they're not eating due to some delusional beliefs in regards to whether food is tainted or poisoned, or whether they don't need food or substance because they have some belief that they don't need that to sustain. So we're looking at a couple of different things with that. Clothing is oftentimes we'll see individuals who are so disorganized with their symptoms that they are not dressing appropriately for the weather. They'll be out wandering around in shorts and a t-shirt and flip-flops when it's 0 degrees outside. So obviously they're not able to recognize that they're putting their physical safety at risk with that. And then shelter is, are their symptoms impacting their ability to maintain stable housing? And that's even, if they are unable to even maintain in a homeless shelter because of their symptomology is getting them kicked out of different places, or if they aren't paying their rent because they're not managing their money because they're so disorganized with those things. And the safety is different in a sense than what we're looking at with dangerousness to self and others. We're looking at inadvertently putting themselves in harm's way. So if the individual is walking into traffic, or they're like with the medications, if they're not taking any of their medical medications, then they're putting their physical health inadvertently at risk. Or if they are interacting with unsafe individuals and aren't able to kind of recognize, which kind of goes into the protect themselves from harm or victimization. That one is a little bit more specific now, in the sense of if they're being taken advantage of due to that, their symptoms of mental illness, if they're in a position to where they're not able to recognize that they're being victimized, or putting themselves at risk where others can harm them. That's definitely kind of that inadvertent safety piece too. And the behavioral control, the times where this addition has really, I think, shown to be necessary. We have a lot of individuals, especially in the areas that I work in, that have excessive use of like 911 or dispatch, times where they're, based on their symptoms of psychosis, they have delusional beliefs that they are in danger, or they're, people are coming to harm them in some way, that they believe that to be very real, and so they're calling law enforcement, they're calling 911, and it gets to the point sometimes where people have been charged with excessive use of 911 or abuse of 911 or misuse or whatever terminology gets used in those charges. Or they're individuals who are engaging with people in the community in a way that I've worked with individuals who believe that somebody in the community is harming their children, so they've gone to that home to try to save those children, which it could be a safety concern for sure, because if that homeowner is armed and feels threatened, that definitely puts their safety at risk. But it also puts the potential for them to be arrested there, and they're not doing it with a criminal intent. They're doing it kind of with that delusional intent. And so we're looking at those sorts of behaviors and things. Sometimes individuals will become confused and disoriented from those symptoms of psychosis to where they believe that they live a place that they don't live in. And so they're trying to enter into the home, just different things like that we can now, just because of those behaviors, look at them for that grave disability criteria. Any questions with grave disability? This seems to be the area that is the most difficult for people to kind of wrap their heads around. Even for when we do trainings for law enforcement officers who take people into protective custody, this seems to be the area that people have the hardest time kind of wrapping their heads around what that would look like, what sort of things meet that criteria. Does anybody have any questions about that? Great. Or you're all asleep. Okay, and the final thing that we're looking at is that lacking that capacity to make informed decisions about treatment. So this is where, like I said earlier, that if somebody's got a guardian, the guardian is able to make those decisions for that individual. They're able to sign them in to the community hospital. They're able to work with the doctors, making decisions about what treatment is appropriate, what medications, and so forth. So what we're looking at for an individual is, do they have an understanding that they have a mental illness, and what treatment is being recommended for that illness, and what are the pros and cons of getting that treatment or not getting that treatment, and their cooperativeness with working with their treating psychiatrist in just overall in receiving treatment in that facility. So it kind of incorporates a lot of different areas, because somebody may understand that I've been diagnosed with bipolar disorder or schizophrenia, or anxiety or whatever, but they're not able to really articulate what treatment the doctor is recommending, or what treatment would be appropriate for those disorders, or they don't agree with the diagnoses and therefore then aren't willing to consider the recommended treatments for that. So we're just looking at kind of that overall understanding of their illness, and then their willingness to engage in the treatment process at the hospital. So exclusions to civil commitment criteria. This is the section when I was talking about the definition of mental illness. They actually have specific exclusionary criteria, some of which actually are included in the DSM-5 as far as dementia, intellectual disabilities, different disorders like that we actually have this section of the chapter where it says nothing in this chapter or any rule adopted pursuant shall be construed to authorize the detention or involuntary admission for individuals that have a neurological disorder, a neurocognitive disorder, developmental disability, a physical disability, or any medical condition that includes psychiatric symptomology, or is primarily impaired by substance use, unless, in addition to any of those above conditions, that person also has a mental illness. And by that, we're looking at essentially what symptoms is the person presenting with, and are those symptoms related to the co-occurring mental illness, or are they related to one of those exclusionary criteria? So neurological disorders, obviously dementia, traumatic brain injuries, different things. The neurocognitives they actually list out, which I'll go over here in a minute, list out specific disorders that are excluded, but Huntington's disease, Parkinson's, just different things like that that can have some symptomology that are psychiatric in nature. Essentially, kind of what the reason why those are excluded is because those are conditions that are not improved by inpatient or outpatient just medical or mental health treatment. So somebody's going to be, with somebody with dementia, if they're going to be hospitalized for their dementia, they're likely not going to be improved by being put on a psychiatric medication and stabilized. So we're looking for conditions that can be treated in an inpatient psychiatric setting. Developmental disability is another one. Now, sometimes those individuals that have been diagnosed with intellectual disabilities is what those are called now, although the statute hasn't caught up to that terminology. But those individuals can also have co-occurring mental health conditions. And so what we would be looking at there really is what are the behaviors and symptoms that are causing that individual to need hospitalization? And is that a part of the intellectual disability, or is that a part of the mental health condition that can be treated and stabilized? Medical disorders that we often see are things like urinary tract infections, UTIs. A lot of times individuals that have pretty significant UTIs will show symptoms of psychosis. And luckily, those are things that get screened for when somebody goes through the emergency department and they get that medical clearance. They're getting labs and they're looking for some of those medical things to rule out. So UTI is one thing. Sometimes thyroid conditions can mimic psychiatric symptomology. Another one is, it's called hyponatremia, which is essentially your sodium levels being low. A lot of individuals who take antipsychotic medications, one of the side effects of those medications are extremely dry mouth. And it will cause an individual to drink excessive amounts of water, which then lowers their sodium levels. And if their sodium levels are too low, you can actually present with symptoms of psychosis. So that's something that would obviously be more of a medical condition, not a psychotic illness. And other things such as like Korsakoff syndrome, which is essentially kind of a dementia brought on by typically a history of alcohol abuse. Those symptoms can appear psychiatric in nature, but they're related more to the medical disorder. So, and essentially as DEs, we're not medical physicians, so we have to do a lot of consultation regarding if somebody has any of those conditions, working with the medical doctors and the psychiatrists that are treating them and saying how much of this is due to this other condition and how much of this is due to the mental illness that they have. and what can be treated and what isn't. And then obviously this impaired primarily by substance use. So that is something that the state of Idaho excludes. If somebody is has a primary substance dependence problem and they don't have a co-occurring mental health condition, that does not meet commitment criteria. So we can't commit somebody just for substance abuse. They have to have also a co-occurring, which a lot of individuals that use substances do have co-occurring mental health conditions. So we're really looking at what is contributing to those symptoms. So if somebody's just going through detox, like alcohol detox, sometimes they can have some pretty significant symptoms that would be considered more of impaired by the substance use, or even kind of alcohol detox is actually a medical issue. So that would be somebody that if they didn't have a co-occurring mental health condition, that we wouldn't be able to use the commitment criteria for. The patient is under treatment by spiritual means alone. And this generally, the courts, in my experience, have really only recognized this in the sense of if somebody is by a kind of a recognized religion that and those the clergy members of that religion are highly involved in recommending something different. I've actually never seen a court not commit somebody because of that particular exclusionary criteria, but it does allow for it if somebody is part of a recognized religion that really is against mental health treatment, and they have significant support from their religious clergy that would show that they would be able to provide that care for the individual, that they would no longer then be dangerous. That probably would be something that the courts would take into consideration. And then can be cared for privately with the help of willing friends and family. This one, oftentimes, family members will say, "Oh, I can," they can come and stay at our house. We can keep an eye on them. And that's really where we're looking at what is the treatment needed. If a patient is needing medication management, medication adjustments to where in the hospital they're getting those on a daily basis, that's not something that friends and family can do. And that's not something that can be managed on an outpatient basis. Most outpatient doctors aren't going to see a patient every single day to make adjustments and so forth. So if the patient has already been stabilized on medication, or they've received kind of like a long-acting injectable to where they can't have any other additional medication changes, and then the family is able to take that individual home and provide an adequate level of supervision, then that may be considered then at that point. But generally, if the patient needs inpatient psychiatric treatment, then what we're saying is they need kind of that day-to-day medication oversight, which can't be done by family. So here's the specific disorders that the statute defines as neurocognitive disorders, which is Alzheimer's, the frontal temporal lobar degeneration, which is another form of dementia, Lewy body dementia, vascular dementia, traumatic brain injury. They also include the inappropriate use or abuse of substances or medications, infection from HIV, prion disease, which prion diseases are things like different, like mad cow disease, different sorts of bacterial or viral things that kind of attack the brain. Parkinson's and Huntington's disease. So we are seeing a pretty high amount, I would say, recently of individuals who are starting to show the early signs of dementia. And a lot of times, it's pretty clear that they're not in the frame of mind to be able to be making treatment decisions for themselves and so forth, or individuals who have traumatic brain injuries, who their level of functioning has gone down tremendously since their injury. That's where we generally as DEs, most of the DEs that I work with over the years we don't just go in and say, nope, they don't meet commitment criteria and that's the end of it. We talk with the families. We really describe kind of the reasons why the people don't meet that criteria. And then we talk about some different options that they may want to consider, because, we can see that the individual is likely not in the right frame of mind to make those decisions for themselves. And that, but unfortunately that because of the way that the statute is written, we're not able to use the civil commitment statute to hold an individual. And that's where family members can talk with legal aid. They can talk with their own attorneys about pursuing a temporary guardianship of the individual. Those can usually be done pretty quickly. I worked with a family just a week ago who was able to get that in place in less than 24 hours. So those things can be a good option. I think the temporary emergency guardianships are good for 90 days, and then they can be extended if need be after that time. Some counties have board of guardians that are a little bit more able to take on patients that don't have family members. We haven't had a ton of luck with every board of guardians being able to do that. But that's something that can always be looked at for individuals that don't have any family members who are able to step into that role. If we've had a few times with hospitals where we've had somebody who has been so disorganized and to the point where the medical they need some sort of medical procedure, and the medical doctor doesn't feel that that individual is capable of providing consent for that. And the hospitals, usually they talk with their own legal advisors, but there's a medical consent and Natural Death Act that's in Idaho code that essentially allows for hospitals to provide kind of life-saving treatment for people that aren't able to provide that consent immediately. So that, if you have questions or interest in that, that is Title 39, Chapter 45 of the Idaho Code. So in reviewing the overall process again, Mary's got she put the link for that Natural Death Act there in the chat. So if you are interested in that, you can click on that. So initially, we've got the kind of that initial protective custody hold, where a peace officer or a physician has reason to believe. They don't have to have proofs. They just have to be suspicious that the individual may have a mental illness and that they're either a danger to themselves or others, or that they meet that criteria for grave disability. And so they place that protective custody hold on that individual. And then that hold again then they have 24 hours to submit that to the courts. So we talked about that can be the court in which the individual lives, or the court in the county of the hospital. And then that court reviews that information and they authorize the hospital to continue to hold that patient. I have seen courts come back if the hold paperwork doesn't have any information on it, or it's illegible or anything like that. I have seen courts deny those before, or they'll send back and say we need more information. But we've worked quite a bit with our law enforcement officers in our hub and with our hospitals to make sure that they are writing out a fairly detailed authorization for their hold, to substantiate the reasons why they feel that hold needs to be put into place. So we don't see that very often here. And then the court will issue the orders for a DE. And so from that point on, if we go in as the DE and we find that person doesn't meet criteria for whatever reason, they don't have a mental illness, they are not a danger to themselves or others, and they're not gravely disabled, then they have the option. A lot of this is another maybe misconception, but a lot of times people, when we go in, they, if we ask them, do you understand what my role as the DE is? They say, yeah, you decide if I can go home. And I always like to clarify that I don't actually decide that they can go home. I decide whether or not the hold stays in place, whether or not that hold needs to continue, or whether or not the hold can be dropped, because there's always the option that they can sign in to the hospital as a voluntary patient. So maybe they've gotten to the hospital, they've recognized, yeah, it probably would be a good idea to stay for a few days and get some treatment here. Then we could drop the hold at that point and they could stay at the hospital as a voluntary patient. Or if they don't meet that criteria and they want to leave, then they have the opportunity to request discharge. And then the hospital then makes the decision if they discharge them just a regular planned discharge where they help do a discharge plan and all of that, or whether they do a discharge AMA, or against medical advice. So that may be sometimes where the doctor feels like, yeah, I think they would need to stay for a couple of days, but they don't meet that criteria, I'm going to discharge against medical advice. So those are the couple of options that happen if somebody gets a negative DE. If they're seen and they meet criteria for commitment, we submit a positive DE, and then that takes us back up to the top in that second section, where then the second DE receives orders and they're seen by that second designated examiner. So again, there are two possibilities with that they could get a negative DE from that examiner, because there's a lot of situations in where the first DE goes into the hospital, sees the individual generally kind of right after they get admitted, but by the time the second DE sees them, it's been a couple of days and the person's doing better and they're either willing to stay as a voluntary patient, or they're doing better enough and that they really can be discharged back out to outpatient services. So if they get that negative DE, then they have those same options. They can either request discharge or they can sign in as a voluntary patient. And if that second DE is positive, then the court schedules a hearing. And then that commitment hearing is held, and both DEs testify. Always before the commitment hearing, we always check in with the patient to see how they're doing, what progress they've made since we've last seen them. Because like I said in that earlier time frame, it can be 5, 6, 7 days since the first DE has seen that patient. So we always like to check in with them, see how they're doing. We get updated progress notes from the hospital. We also check in with the current treating psychiatrist, because sometimes if the patient sees one doctor kind of that first week and then the hearing rolls into that second week, sometimes they have a different doctor by that time. So we want to check in with the most current treating psychiatrist and see kind of what their thoughts are and how that person's been doing, how they've been participating in treatment, so forth. And sometimes at that point in time, we're able to say, it doesn't sound like they meet that criteria anymore, and we can drop the proceedings even before the commitment hearing. So at any point in time, this process can be halted. So that's something that I should have said earlier too, but that's something that we're constantly kind of checking in to see, because the minute that person no longer meets that criteria and is able to resume their own decision making, we want to make sure that happens. So if we've both checked in with the individual and they still need treatment on an involuntary basis, then we would have that hearing. We'd both testify to our findings at that hearing. And the patient has the ability to testify. They'll talk with their attorneys about whether or not they want to testify, whether or not they just want to make a statement to the court. They have the ability to decide. Sometimes family members want to be present for the court hearing. That's always up to the patient. If the patient wants them there, then they can join in the hearing. If the patient doesn't want them present, then they can't. That's the patient's decision. So after that hearing is held, and then a few things can happen as a result of that hearing. That if we have met with a person and didn't have enough time per se to cancel the commitment hearing because they no longer meet that, and that information is presented during the court hearing that person no longer meets that criteria, then the attorneys can withdraw that commitment petition and the case will be dismissed at that time. If we do all of our testimony and the judge makes the decision that the state hasn't provided enough evidence, that they're not able to, they don't find that person meets that commitment criteria, the judge is able to dismiss that case and find that they don't meet that criteria, and then the patient is released at that point in time. The hospital has to release them, or the judge can find that person meets all of those areas of commitment criteria. Clear and convincing evidence is the language that the court uses, and they're committed for that period of time not to exceed 1 year. So after that commitment's in place, that patient stays then at the community hospital, and they can go on the wait list for State Hospital South, State Hospital North. And then depending on whether or not, depending on how long the wait list is, generally it can be up to about a week, sometimes longer, before that person, their name comes up on the list for State Hospital. At that point in time, we check back in with the treating psychiatrist at the community hospital and say, is this something, do you feel like the patient needs to be transferred and continue treatment at the state hospital, or do you feel like they can be reevaluated or are going to be ready to be discharged in a day or two? And we'll work then with the community hospital for that reevaluation. Or if the doctor feels like, yeah, they're going to need some longer term treatment, then we'll make arrangements for them to transfer to the state hospital. And when they go to the state hospital, then the original DE is kind of out of the process. We only are involved in the reevaluation process if we do that from the community hospital. If they go to the state hospital, then they have their own treatment teams there that make all of those decisions. So that is the civil commitment process. Just the basics, but does anybody have any questions?
I really appreciate this. I was paying really close attention. Well, first of all, I really appreciate the updates to the lodge, the verbiage changes around gravely disabled. That's really helpful because I don't know that local law enforcement always is knowledgeable about that. And I'm speaking from a different region than you are, but I've run into that fairly consistently. So that's really helpful to know about, to have that language. So thank you. Second of all, too, I'm just kind of running back to, I work in aging now, and I'm just kind of going back to that piece around like Alzheimer's, dementia, and that whole piece. I think too, we're seeing those folks that have like those co-occurring like mental health and neurocognitive disorders. Like,
Mhm.
I feel like I'm asking kind of a rhetorical question almost, because I know those are really difficult scenarios, but where do those folks kind of fall on the line? Like, when does one overweigh the other?
And that really, it's kind of case by case. What we really look at is what are the symptoms that they're presenting with. So what's kind of caused them to need to be hospitalized, and
Mhm.
then working with the treating psychiatrist in what do they feel those symptoms or behaviors are more attributable to. Are they attributed to this underlying or co-occurring mental health condition, or are they really related to the dementia and Alzheimer's? So is it something really that they feel can be treated?
Mhm.
So sometimes it's not clear to the point where
Sure. Yeah.
and so then at that point in time, if the doctor's feeling like it could be due to the mental health condition and they'd like to try and work with the patient to treat it, then we're testifying to that being the case, that it's more likely that it's due to the mental health condition, and that the treating psychiatrist actually feels that some of those symptoms can be treated. And so they're recommending continued inpatient treatment with the medication. But if the doctor says, no, this is clearly dementia, there's nothing really we can do for those symptoms or behaviors, that then, our hands are kind of tied in that sense, to where we're not medical professionals. And so when the medical professional is saying this is dementia, this is not a treatable condition, then we really can't argue with that. So
I really appreciate that. Thank you.
So these are just the sources that the first one is essentially the overview of all of the statutes, Title 66, Chapter 3. And then the second one is I believe that's the Medical Consent to Natural Death Act. And then the final one is just the federal Firearms Act that prohibits people that have been committed civilly from purchasing firearms. So, and I do believe that those are all, Mary's put them all in the chat too. So, and I think she's also going to be sending out an email that will have all of those links as well.
I will.
Okay. Mary's also included my email there in the chat. So if any further questions or thoughts or anything come up, certainly feel free to reach out to me, and I can try to do my best to answer the questions, or whatever. It doesn't have to be right away either. If you think about things kind of along the way, I'm always available. The area of civil commitment and designated exams is my my specialty in the department. So anytime any questions come up regarding that, you can always reach out to me.
Jessica, there is a question in the chat. What resources do you recommend to get more information on the commitment process relating to criminal cases?
So that would be the Title 18, Chapter 2. Yeah, Title 18, Chapter 2. The 211 and 212 is the competency. So 211 is the question of whether or not someone is competent. So that allows for a psychological evaluation to determine competency. And then 212 is when somebody has been determined not competent to stand trial. And then that allows for the competency restoration. And I believe Title 18 is actually the criminal codes for Idaho.
Well, I just have to say thank you so much, Jessica. What an informative presentation. we're really happy that you know all this stuff and can teach us about it, okay?
Oh, thank you.
I want to remind everybody to check your confirmation or your reminder email for the full CEU requirements. And you will find your evaluation email in your inbox within a couple of hours. And I'll send an email probably tomorrow with all the links from the session and the link to the PDF of the slides. And you can directly send direct questions to the Empower Idaho email, which I'm putting in the chat right now. And let's hit it in there. The slides and the recording will be available on the website in a few days. And thank you all for attending and making this such a success.
Thank you, Mary. Thank you, everybody.
Thanks again, Jessica. Everybody have a great day. Bye.